In the first part of Chapter 12, we're going to talk about warranties and product liability. Next week, we'll talk about consumer law. Generally, warranty is an assurance or guarantee by the seller or lessor of certain facts concerning the goods being sold or leased. If a seller breaches that warranty, a buyer can recover damages or rescind the contract. Some warranties automatically arise in commercial sales transactions. We'll talk about the warranty of title as an example. Normally, warranties can be disclaimed or modified with specific language in the contract. One type of warranty is the warranty of title. It's created by the Uniform Commercial Code. It expressly warrants that the seller has good title, that there are no liens or encumbrances on the goods, and that there is no infringing use. In other words, there's no interference with intellectual property rights. An express warranty is a representation concerning the quality, condition, description, or performance potential of goods. It could be everything from what somebody says to what they write, an affirmation, promise, description of the goods, a sample or model. The buyer must rely on the warranty when they enter into the contract. In other words, it needs to be the basis of the bargain. And only statements of fact qualify as an express warranty, not statements of opinion or value, or what sometimes is referred to as puffery when somebody is engaging in sales talk to build up the product, which a reasonable person would recognize as an obvious exaggeration and not an express warranty. One exception to the idea of opinions not being a warranty is that if the opinion's offered by an expert, then that would be something that somebody would reasonably rely on. One type of implied warranty is the implied warranty of merchantability. In terms of goods, it warrants that they are of average, fair, or medium grade, they're adequately packaged and labeled, they conform to the promises on the label, and have consistent quality and quantity among the commercial units. In terms of commercial merchantability of food, it's based on the consumer's expectations. An example is case 12.1 Webster versus Blue Ship Tea Room, where the question was whether the implied warranty of merchantability was breached when fish chowder was served with bones in it. The court determined that it wasn't. Another implied warranty that isn't automatically created like the implied warranty of merchantability is the implied warranty of fitness for a particular purpose. This only arises when a seller knows the particular purpose for which the goods are being bought and knows the buyer is relying on the seller's skill and judgment to select suitable goods. You could have goods that are merchantable but not fit for a particular purpose. You could have goods that are impliedly merchantable and fit for some particular purpose. Again, the key is knowledge and reliance. The seller must have reason to know the purpose, and buyer relies on that recommendation. One of the most obvious ways the seller would know that is if the buyer informed the seller of the specific purpose. There also could be an implied warranty from prior dealings or trade. And in some cases, all these express implied warranties. There could be overlapping warranties. If they're consistent, they're construed as cumulative. In other words, they build on each other. If they're inconsistent, priority is first given to implied warranty of fitness for a particular purpose. Samples take precedence over inconsistent descriptions, and exact or technical specifications take priority over inconsistent samples or descriptions. You can disclaim a warranty, in other words, attempt to avoid liability for a warranty. Express warranties can be disclaimed if they were never made in the first place, or if a clear written disclaimer in the contract using specific unambiguous language called to the buyer's attention. An example would be, different bold caps underlined. The implied warranty of fitness and merchantability can be disclaimed with words such as is or with all faults. The disclaimer of the implied warranty of merchantability must use the word merchantability, and a disclaimer of the implied warranty of fitness needs to be in writing and conspicuous. The Magnuson-Moss Warranty Act is a federal law that modifies the UCC for consumer sales. It applies when written warranties are made by a seller. It doesn't require written warranties, but if they're made, if the goods are valued at $25 on the label, it must state if it's a full or limited warranty. A full warranty means the seller must repair or replace the product. A limited warranty needs to be conspicuous, and it could be a limitation of duration of parts that are covered, etc. If it's a limit of time only, then it needs to say, for example, a full 12-month warranty. UCC implied warranties may not be disclaimed but can be limited, but must correspond with the time of express warranties. And it requires the documentation of all warranties in readily understandable language. There are also lemon laws out there that protect consumers, applying to cars, usually new cars, that maybe have been even subject to warranty work, but the problem's still not fixed. These statutes provide remedies to consumers. Usually there's some requirement to have the seller reasonably attempt to fix the defect. If not, the buyer would have a remedy of either getting a new car, replacement of the defective part, or return of their money. And arbitration is usually a part of these statutes. In the area of product liability, this is a lot like the tort chapter. It's not a new tort. It's just applying tort law to product liability. So the areas of negligence, misrepresentation, strict liability, and warranty theory, which we were just talking about, are not new. A consumer could claim that a manufacturer's breach of a reasonable standard of care caused them injury. There's a presumption that a manufacturer, seller of a product, exercises due care. The manufacturer exercises due care in the design, selection of materials, using appropriate production processes, how it's put together, how the warning that's on it needs to be adequate, inspection, testing, those type of things. You don't have to have privity of contract in this case between the plaintiff and the manufacturer. In other words, the party that's harmed doesn't have to purchase it directly from the manufacturer. And liability extends to any persons who are injured by a negligently made or defective product. Misrepresentation, this occurs when there's fraud committed against the consumer or user of the product. It must have been knowingly or recklessly made with disregard for the consumer's safety. And the plaintiff in this case doesn't have to show the product was defective, just that they were injured and that there was fraud committed by the seller or manufacturer. There's also strict liability. In terms of strict product liability, it holds people liable for the results of their acts regardless of whether they were negligent or intended the harm. The idea is it protects consumers from unsafe products. The manufacturer or maker of the product shouldn't be liable because they made it, and they typically have more money to bear the cost of the injury. There's 6 requirements for strict product liability listed in your chapter. They're listed here. Typically in these statutes, the product is required to be in defective condition when it's sold. The defendant is in the business of selling those type of products. It's unreasonably dangerous, which it depends on whether the statute addresses that or not. It harms the plaintiff, and the defect in the product was the proximate cause of that harm. And the goods haven't been substantially changed. They haven't been modified. There's three general categories of defects: how it was put together, how it was manufactured, the design of the product, and the warning can even be defective. Um, a manufacturer has a duty to warn of risk associated with a product, not of obvious risk, but and if they fail to do that, perhaps they know of a risk that has come up or it's foreseeable, then they should put that on the label. Other applications of strict product liability: virtually all courts extend strict liability to injured bystanders, and the strict liability also applies to suppliers of component parts. There are some defenses here. Preemption, in other words, the government regulates in the area of product liability. Assumption of the risk, although not usually in strict product liability claims, the idea that you knew of a risk associated with the product but you did it anyway. Smoking is a good example of that. Product misuse, which is pretty limited because a manufacturer has a duty to warn of foreseeable misuse of the product. Comparative negligence, how at fault was the plaintiff in their use of the product. That it's a commonly known danger, knives or sharps, or knowledgeable user, that this particular user should have known better when using the product.